When I'm walking down the street.
I do want to say to Doni and many of you in this room that over a very long career in this city, all of you have helped me and my colleagues tell the truth and to try to tell.
I may not look like you and you me, but
Put my hat up.
I'm from South Carolina, so I just...
What does this event mean to you, Miss Peggy Mars?
Oh, my heart,
Happy 20th anniversary.
my heart is about loving up on my sisters. Do you know what it feels like to have your sisters in the room? John.
And dare to be different and unique. I'm gonna be the best me I can be by letting His glory shine through. I am beautiful, I am blessed, but not just what you see in the flesh. I'm free from people, free from myself.
The doctor lived next door to the janitor, to the reverend, and the lawyer. We were together. Now we get so high and mighty that you create stress for your society because you don't like poor black folks either. That's a health problem. Get yourself together so I can stop being taking care of geriatric people and get back to pediatrics. I thank you, Doni, for all you've done. Let's keep doing it all and more.
Letting His glory shine through. Dare to be you, dare to be me, dare to be different and unique. I'm gonna be the best me I can be by letting His glory shine through. And I dare you, I dare you, I dare you to be you.
First name's Doni, last name's Glover, in it to win it for the long haul, baby. Listen, if you're like me, you grew up learning how special basketball is and football. It's America. You had to have some kind of game. Little did we know just how valuable that is. Today we have with us attorney Patrick Bradford. Good morning, sir. How are you? Oh, your volume. And I do understand those technical challenges. You there? It's okay. Take your time. Basketball. I love basketball. Let's try them again. We've learned with the internet what can go wrong will go wrong. I knew at 13 I wasn't going to make it to the pros. Not in basketball. Might have had a little shot at baseball, but the competition is so thick. Things that work when you were young didn't necessarily work when you got older. But some do make it. It's just a long shot. And in the black community, it's like rap. You had to have a wicked jump shot or you had to rap. That is if you didn't know your gifts. I came to realize my gift was not basketball. It wasn't football. Tried. But some people it is. No, sir. For some people it is. It is their gift. And you learn with your gift that it may not be what you want it to be. But once you find your gift, ain't no stopping us now. You also learn in America the black athleticism. I hear you now. So we're going to remove that one. We're going to try this one.
Is that better?
I hear you now.
Can you hear me now?
Loud and clear, attorney.
Oh, good, good. Okay, I just switched to my cell phone. Okay, I don't know what's going on with the computer. Good to be with you.
Did you play ball coming up?
I played basketball at Hammond High School in Columbia, Maryland, before going off to Harvard College, where I played intramural basketball. And I've always been a sports nut, especially basketball. Growing up in Maryland, my mother and I used to love to watch the Hoyas with John Thompson. She was a big fan of his for a whole lot of reasons. He was an excellent coach, but his emphasis on education for his children and for his players. My mother was an educator, so she was a big fan of his.
What year did you come out of high school?
I graduated from Hammond High School in Columbia, Maryland in 1982. Went to Harvard College, graduated in 1986, then went on to the New York University School of Law, graduated in 1989. So
how'd you fall in love with New York City?
Old. I went to law school here and just decided to stay.
Now, see, usually I hear the story in reverse. People go to Atlanta, they go south. but how often do we hear of because we're mid-Atlantic.
Mid-Atlantic, yes.
Falling in love with, I love New York City. I don't know if I could live there though.
Well,
I like that. We got elbow room here in Maryland.
Yep, I know. My brother and my sister live in Maryland. And as I said, I graduated from high school in Maryland, but I've got something even worse for you. My family's originally from Alabama. I actually grew up in Huntsville, Alabama. Then my daddy got a job teaching at UDC in Washington and moved the family to the DC area.
Man, I just got off the phone with a UDC legend, Chu Smith.
Mm-hmm.
Chu Smith is a Harlem Globetrotter.
Mm-hmm.
And he just landed a $600 million deal to train young people.
Well,
nationally.
Let him know if he gets in any legal trouble and he needs any representation, he can give me a call.
We'll be sure to.
Absolutely.
So I get this email from you, and long story short, you bring to light about D1 athletes, Black D1 athletes in particular.
Yep.
So $2.8 billion has been made available from a settlement. What happened?
So the issue of NIL has been in the press a lot because for many years, the NCAA had rules prohibiting member schools and their players from profiting off of their name, image, and likeness. A couple of years ago, the NCAA reversed that, principally because the state of Florida passed a law saying that its schools had to permit it. And then the NCAA knew that other schools outside of Florida would be at a competitive disadvantage. So they changed the rules. And so now we have across the country a lot of students making money off of name, image, and likeness. Some of them.
That's what NIL is.
Yep, name, image, and likeness, which basically means that each individual has the right to control marketing their own name, image, and likeness. And NCAA rules that prohibited that were wrong. And so the state of Florida first said they were wrong, then California, and then the NCAA basically had to eliminate those restrictions. And so we now know that young men and women at all levels have been making money off of name, image, and likeness in various ways. Some in podcasts, some doing pictures with a local car dealership, large and small. Some very, very large superstars making money. And of course, this helps with the cost of college education. It also helps their families at all levels. A lawsuit was filed by a group of very prominent lawyers They're the same lawyers that represented students in the 2021 Alston decision before the Supreme Court. In the Alston case, the court ruled 9-0 that certain limits on student benefits that were related to education could in fact be paid to students, notwithstanding the NCAA regulations prohibiting that. And so that was a landmark case. What that case didn't do is it didn't get rid of NCAA rules that prohibit pay to play. What's pay to play? It basically means that a school would pay an individual player what the market would bear, what that player would be worth on the open market. So not limited simply to room, board, and tuition and these additional benefits that were made available by Alston. And that's the big issue because that's a lot of money. So Alston was a huge victory for students, and it was a harbinger of what might come. So the same lawyers who won that case brought another case saying that the NCAA's prohibition on letting students use their name, image, and likeness for past years was a violation of the antitrust laws. And that case is being settled in part with this proposed settlement. Now, the way the settlement works is it's a proposed settlement, but if you don't get your claim in and the settlement is approved by the court, then you get nothing. So there's a settlement pool of money of $2.8 billion. And you have to go online or either mail in a form by this month, by January 31st of this month. So it's easy to go online. And the most important thing is the website, which is www.collegeathletecompensation.com. So collegeathletecompensation is one word.com. You go there, and there are two different forms because there are two cases. One is House and one is Hubbard, but House is the big one. So if you played any D1 sport, baseball, basketball, any D1 sport between 2016 and 2024, you can go to that website.
Is that right?
And it's collegeathletecompensation.com. So .com. So you can take out the form. So it's just www.collegeathletecompensation.com. So you go there, and then there's a lot of information, but the most important thing is to click the link that brings you to the form, and it'll ask you questions. What years did you play? What sport did you play, etc. Now, one of the important things that we found out is that if you do not have your eligibility number, right, you put that on the first screen. You say, I played basketball, I played football, I played whatever, and then you say, I don't have my number. It brings you to the actual form screen. And when you get to that second screen, for some crazy reason, it requires you to put in the number that the preceding screen told you didn't have to have. If you don't have your number, just type the word unknown in that box, complete the rest of the form, and press send. I've gotten a couple of questions about people who press send and then have additional information to update their form. So when you send in your form, you'll receive a number, an identification number from the settlement administrator. If you later have additional material, you email the settlement administrator and you use your claim number so that they can match up any additional documentation that you have with your claim. Now,
attorney.
Yep.
How do you benefit?
You mean me personally?
Yeah.
If there are Black kids out there who have money that is due to them, that's how I benefit. My law partner, Denver Edwards, and I are doing this as a service to the Black community. In the Alston case, we filed an amicus brief on behalf of Black athletes, making our position known. And this is just an extension of what we did there. Justice Kavanaugh cited our brief when he was making his point about the importance of compensation to these athletes, how they work hard and have created this billion-dollar industry. And he noted that many of the star players in the basketball and football area are Black and come from humble backgrounds. So now this is a part of the Supreme Court record. We know that our young men and women have made this industry, and the idea that there would be a pool of money and Black D1 players would not hear about it and would essentially forfeit their rights it is untenable, honestly. And so that's why we're doing it. We're
This
just
is
trying
public
to get
service.
it's public service, pro bono. It's pro bono. And look, the most important part of this is people like you, Mr. Glover, who are helping us get the word out. Even though the notification has been going on since October, we just recently found out about it. And with this deadline looming, it's really serious. We're considering asking the court to extend the deadline, but unfortunately, we can you can't go with that. You have to try to reach as many people as possible. The other thing is because I don't want to. The judge here, Claudia Wilkin, is an excellent judge. Her ruling in Alston was upheld 3-0 by the Ninth Circuit and then 9-0 by the Supreme Court. So the judge who the case is before may well be the most qualified and experienced judge for these kinds of sports antitrust, college sports antitrust cases. And a part of the case was approving a notification, a media notification plan. But that plan, which I've read and is very thorough or extensive, really depends on social media. The idea being that players who played between 2016 and 2024 are younger, and therefore younger people rely on social media, and so most of the advertising and notification has been through social media, and I understand that. But my view is that the Black community works a little differently. So one, the Black community, the Black young men mostly made this industry, and there was nothing that's specifically Black marketing in the court-approved plan. And my view is these athletes will learn about the settlement not just from social media, but they may learn about it from a father, a mother, an aunt. Someone who's listening on your radio show may say, "My nephew played D1 ball, and he may not have heard about it. She may not have heard about it. Let me call." So the idea is to try to get the word out to the larger Black community in hopes of reaching young men and women who are a member of the class. Now, again, the settlement is for any D1 player of any race that played any sport between D1 sport between 2016 and 2024. However, when you look at the breakdown of the estimated payments, the largest payments will be going to men's basketball players and football players because they created so much of the value here. And the estimated payment is between $91,000 and $280,000 a player. And that's a lot of money. So on one end, you have the current NBA and NFL superstars who played D1 ball between 2016 and 2024. They may well certainly qualify, probably for the high end of the spectrum. But in addition, our concern is for the great majority of players who played D1 ball, maybe were injured, lost their scholarship, and maybe now working pumping gas or a minimum wage job. Those individuals certainly could use the funds from this settlement, but first they have to find out about it and register. And the way it works is, if you don't register by January 31st, you may lose your right to claim the funds. I should say this, and I do want to say it. But the headline is, please go to www.collegeathletecompensation.com and register. When you register, what you're doing is you're reserving your opportunity to claim the funds if the court approves the settlement. Now, the court may not approve the settlement. The judge probably will approve the settlement. The court may approve the settlement with modifications. We don't know what will happen. There are always hurdles. But the way things are situated right now, if you don't get your claim in, then you may lose your right for any money, and that would be a crying shame. Now, let me say this also. Last week, right at the end of the Biden administration, the Biden administration's antitrust division of the Department of Justice filed a brief before Judge Claudia Wilkin. And in their brief, the Biden administration said, we take no position on the portion of the settlement dealing with the $2.8 billion NIL settlement. So they're not objecting to that, right? And I'm not objecting to it in the sense that I want as many Black players who qualify to actually go in and fill out the form so they can preserve their right to get their money. But there's a second part of the settlement, and the second part of the settlement involves an injunction. And what the Biden administration said in its brief is they contacted the lawyers for the NCAA, and they said to them, do you intend to use this portion of the settlement to prevent players from bringing lawsuits to claim their full compensation? So remember, the settlement that we're talking about is name, image, and likeness. The other part of the case that's being settled is the right to sue for the compensation that you would have received if there were no rules in place. So the way I think about it is this. All of the superstar players who are currently playing in the NBA and NFL, who were D1 players at one time, if their schools had had to pay them what they were actually worth, in other words, not NIL, but if the schools had had to pay them direct compensation for their athletic brilliance, it would have been much more than the room and board. And this settlement, this settlement includes provisions that basically say those past payments are out, and any future payments will be capped at about $23 million per school. And the Biden administration said it didn't like that term because it basically limited the amount of money that players could get if, in fact, a court were ever to go all the way with the Alston ruling and say, as Justice Kavanaugh said in his concurrence, all of this is a violation of Section 1. You simply cannot create an industry by saying that the industry is based on not paying the players, which is the NCAA's mantra for years and years, that amateurism or not paying direct compensation for the talent of athletes is necessary in order to maintain interest in the sport. The Supreme Court, but certainly just
could you say that again?
Sure. So, in his concurrence in Alston, Justice Kavanaugh stated his position that the NCAA's justification for not paying players compensation for their athletic brilliance, according to Justice Kavanaugh, that justification is not doesn't hold water, because what he said in his concurrence is you can't define an industry by not paying the workers in the industry. And it's clear from the 9-0 ruling that if that issue had been in front of the Supreme Court, the Supreme Court might well have overruled all of the NCAA rules prohibiting direct pay for work.
And made this, instead of $2 billion, $50 billion.
It would have been much more significant. And at the same time, you have to understand the NCAA is very powerful, so they're running to Congress trying to get an antitrust exemption so that they can continue doing what they're doing, and this settlement may give them more time. Again, they're emphasizing the $2.8 billion NIL portion, but what's not being emphasized is what the Biden antitrust division emphasized in its brief, which is that if you don't opt out, then you're going to be locked in, and if you were to bring a lawsuit seeking your compensation because you weren't paid later on, the NCAA would say
sorry, too late.
Exactly. This settlement boxes you out. Now, of course, many people may appeal the settlement, and they may win. But as the terms are right now, that's where we are.
Okay. I don't mean to cut you.
Yep.
Antitrust laws.
Yep.
Can you break that down for the layperson?
Yeah. I mean, it just means that employers can't get together and agree that we're only going to pay $2 an hour to all the workers. In other words, price collusion under Section 1 of the Sherman Act is prohibited. So what's going on in the NCAA world is, because of the NCAA rules, the NCAA and all of its member schools are getting together saying, you may not pay the players what they're actually worth. You can only pay tuition, room, and board, the cost of a college education. And that's price fixing, because there's an artificial ceiling on the compensation that a player can get. So in the Alston case, one of my favorite facts in the Alston case, in the trial record, was that certain schools were insuring their superstar players for $5 million, $10 million. So schools were insuring players against injury for millions of dollars, and yet only paying the players the cost of the tuition, room and board, and certain, certain special athletic awards that were in the thousands. And so just that fact shows what the issue is. If you're insuring a guy for $10 million and you're only paying him $75,000 a year for room, board, and whatever, then you know that there's something wrong. Guess what? He's worth $10 million, right? And so if there's a lawsuit that's brought saying that young man who's now in the NFL should have been paid $10 million by his school and college, and he doesn't opt out of the settlement, then the NCAA's position is going to be you've lost your opportunity. And so, and I know this is a little because my concern and the concern of my partner Denver Edwards, our concern is really for kids that didn't make it to the pros, and that's 95%, about 95%, who got injured or who maybe graduated and didn't get a full education and are struggling. We want them to get their money. But and again, if a group of professional athletes from the NFL and NBA decided to opt out, and they'd have to do so by the 31st, and really, this is a matter for the respective players' associations for the NBA and NFL. But if the superstar players were to opt out, they would preserve their right to then bring that Alston 2 lawsuit seeking millions of dollars, because they certainly were the ones who made the industry and the other thing is, there are treble damages in an antitrust lawsuit. That means it's 3 times what the real damages are. So really, my hope would be that someone would contact, and I've been trying to, but I mean,
Trying to contact who?
uh, uh, to, to contact the players associations for the NBA and the NFL to have their members opt out of the settlement and therefore preserve the right to bring the what I call Alston 2 lawsuit for the full compensation, because then the NCAA would have to sit up and take notice, and it would be a lot of money, not just a victory going forward for future players.
So
Again,
you really need current NBA, NFL stars who just came out over the past 8 years.
Yep, who played D1 ball between
D1 ball.
2016, who played D1 ball between 2016 and 2024, to think about opting out. And I say that to think about because they're probably in a financial position where they wouldn't need the $280,000. By opting out, they would preserve their right to bring a lawsuit and get the actual compensation that they deserve from their years. So in other words, they might be, and it's all might, because you never know how you're going to win, right? You never know if you're going to win. It depends on the judge. It depends on a whole lot of things. But given the Supreme Court's ruling in Alston, players are in a much better position. So the idea would be these superstar players might be $280,000 in the near future for perhaps millions of dollars down the road. And even if they didn't win, the point is that they can afford to. Players who were injured, who are working minimum wage jobs, who are pumping gas, who are just trying to make ends meet, just their financial position is probably going to dictate that they get their settlement in, that they not object to the settlement. Again, my firm is Bradford Edwards LLP. We're based in New York with an office in Los Angeles. We do corporate litigation, so we do antitrust cases. We are not the lawyers in this particular case, but I've been an antitrust lawyer for 30 years, which is one of the reasons I was monitoring the case and one of the reasons we submitted our amicus brief in the Alston case on behalf of Black athletes. So
what's an amicus brief?
Amicus brief is a friend of the court brief. It's saying we don't have a client here, but the issue is so important to us because of what we care about in the world that we want to put these issues before the court. And there were many amicus briefs filed in that case. And when Justice
how do you spell that?
AMICUS.
Amicus, okay.
Yep, amicus brief. For my law firm, and look, we represent corporations and high net worth individuals, pharmaceutical companies, Fortune 1000 companies, small businesses in federal court litigation, whether it's accounting defense, bankruptcy, antitrust. We represent financial institutions. My partner have been partners in other major Wall Street firms, and we decided about 5 years ago that we were just going to start our own firm, so we would only have to report to each other, and basically continue doing the kind of high level corporate litigation work that we were trained to do from the time we were young associates working on Wall Street. But one of the great things about having your own firm is that you can decide without having to get it cleared by other people who run the firm, since it belongs to you. You can decide what to do with your goodwill and your resources. And my buddy Denver played, he was on scholarship at Middlebury, where he played football, and he's a big sports nut. And he's got 4 boys, and he's a big sports nut. I played basketball, as described. And so we know that Black players built this billion-dollar industry. We know, and it was a part of the Alston record. One of the NCAA commissioners said, when diverse students started coming into the schools in greater numbers. Diverse is code for Black, right? When diverse students started coming in, that's when we started to see the explosion in viewership on television and selling those TV contracts is the fulcrum for bringing in hundreds of millions of dollars to the individual schools. The schools now control contracts for football. The NCAA continues to control the basketball March Madness, but there's so much money coming in from broadcasting rights from sports, especially men's basketball and football, which is why they're getting the lion's share of the NIL settlement. But it does beg the question, if a guy is insured for $5 million and the NCAA rules and the college rules say that you can only pay him room and board, what's really going on there, right? And
It's called big pimping.
I've said this before, and I believe it because I'm a 60-year-old Black lawyer from Alabama. If white boys had created a billion-dollar enterprise, there is no way that they would be paid pennies on the dollar. And even with the win in Alston, right, which was significant, the most important thing about Alston is it was a harbinger of what might come if all of these NCAA rules are declared void under Section 1 of the Sherman Act.
All right, look, Mr. Bradford, I done let you slide for 38 minutes.
Okay.
This has been the Patrick Bradford Show. This is Donnie Glover just chiming in. No, hold up.
If you have any questions, go ahead. I
got a bunch of them. First of all, you are the celebrity.
Oh, no.
Oh, yes. No time for modesty, Attorney Bradford. I want to know, in your matriculation, did Reginald Lewis, did his history ever come across your desk?
Well, I mean,
he's from East Baltimore, and we graduated from the same high school, Dunbar, and I came out in '83.
Yep.
But the year you graduated high school, you probably heard of Dunbar and the legends that came out of there. All of that to say, this story touches home.
Yeah.
I graduated with those guys. I ended up going to Morehouse and following English and media, but I was right there with those guys. And I don't know that they know about this.
Yeah. Well, Reginald Lewis.
So did Reginald Lewis come across your desk?
So Reginald Lewis, of course, is an icon among lawyers in America and the world because of all he did with Beatrice Foods and his really landmark work. I never got a chance to meet him, though. Of course, I have his book. Why should white guys
have all the fun?
Yes, it is a part of my library. I did at one point in my travels in New York City get to meet his wife, who is also an attorney and a wonderful lady, and his daughter.
Loida.
Yes. I do a lot of not-for-profit work, and I met her on a not-for-profit board for one of the Black dance companies, and she's a wonderful lady. So of course I know who he is, and I know what Dunbar High School is because one of my best buddies and the music director at my church went to McKinley High School before going to Howard. I have to call him Dr. Banks now because he's got 4 academic degrees. And my pastor is also a double Howard person and taught in the public school system in Washington, D.C. before he got the call and went to divinity school. So absolutely. I absolutely know of Dunbar and many of the great high schools in Washington, D.C. And back in the day when you graduated, they were even more prominent in a range of things, from sports to music to their academic rigor. I mean, there's still great schools. One of my mentors here, who was first Black U.S. attorney for the Eastern District of New York, which is Brooklyn, Zachary Carter, I believe, is a graduate of McKinley High School as well. So,
okay, then I want to ask you about. I got to get your thought. I hear it all the time. College is not for everybody. Attorney Bradford, I argue, given that our ancestors, many of them, learned to read when doing so could have cost them their life. When I think of your journey from Maryland to Boston to New York, when I look out on Pennsylvania Avenue in Baltimore and I see a young man riding a dirt bike against the traffic with one hand, navigating, maneuvering. And then when I think of the young man that gets over to the city jail, and the first thing they have him do is go to class. So you got locked up to go to jail to go to class. When I think of America being 5% of the world's population, yet having 25% of the incarcerated persons and 38% of them being Black men and Black women being the fastest growing demographic, I ask you, Attorney Bradford, why isn't college for everybody? Even a carpenter has to know how to count his money, or he's going to pay an accountant who's going to charge him extra if he can't count.
Yeah. I mean, it's a good point. And a related point is there are a whole lot of different kinds of colleges, right? There are community colleges. First Lady Joe Biden made a big deal about community colleges, and sometimes they're terrific because if you haven't been prepared thoroughly in high school, you can go to a community college, get up to speed, and then if you want to, apply to a four-year college based on your community college record, and that means that the total cost of your education will be much lower. So there are a whole range of community colleges. Tuskegee Institute, which is my mother's college alma mater before she went to Penn State for her graduate degree, began in that vein, and now Tuskegee offers a range of majors. One of my best buddies majored in computer science and minored in mathematics, and he's had a fantastic career working for a financial institution for over 25 years. HBCUs are going to become much more popular now that the Supreme Court has outlawed affirmative action in college admissions. And so it's kind of cyclical, right? But HBCUs have always been a lifeblood in the Black community, always. And so college is something that everyone should consider. And the real issue is, I think one of the real issues is the education that's being provided to Black children nationally. Is it preparing them for somebody's college? As I often say, apply. You can always turn it down, but if you don't apply, you can't go. And it's kind of the same watchword here with respect to this NIL settlement. You need to apply so you can preserve your right to receive these funds should the court approve the settlement. So,
so let me just jump in on that.
Hmm?
Right now, suppose a larger platform like a Byron Allen caught this story, and he's not my favorite, but say a Stephen A. Smith.
Yep.
How do we get this story to them? I mean, I'm going to do my part. I'm going to make a phone call. You said
Yep.
you need the Players Association.
Yep.
How do we get this story? I mean, you know, if it's something dumb, like a wardrobe malfunction during the Super Bowl halftime show, it goes viral. If it's some white people doing a black people's dance with their daughter or granddaughter, it goes viral. How do we make this go viral?
Well, I think that people like you who have shows like this and a platform are the best way. So one of the things that my firm did is we sent our press release and explanation to about 400 members of the Black media, and you returned the email. There was a lady from a radio station in Mississippi who returned the email. We've been trying to reach out and get to people like Stephen A. Smith, Tavis Smiley. We've been trying to reach out and get to a larger audience. Um, and I'm a firm believer in you keep on trying until the deadline. And so we'll keep on trying to get the message out until 11:59 California time on January 31st of this year. Um, um,
Millions of dollars are going to be missed. That's what it's looking like.
Yep. Here's a story that emphasizes the point. There is a current lawyer. His name is K. Braden Anderson. He played for 3 D1 basketball schools, including Seton Hall. While he was playing for Seton Hall, he went to Seton Hall Law full-time, graduated, worked at 2 Wall Street firms. Now he has his own law firm. I worked with him a little bit on the Alston case. So I reached out to him. And when I reached out to him because I know that he has a network of players, and I wanted to ask him, could he access his network to try to get the word out? And he said to me, what are the years, Patrick? And I said 2016 to 2024. He said, that's me. He said, I'm in the class. And I said, oh, he said, I hadn't heard about this. And so he went online to register, and he ran into that problem. He didn't have his eligibility number, and he couldn't actually get the form to go through. That's how we found out about that glitch and having to put in unknown. But it occurred to me that if a lawyer, you know, this is a 6'9", you know, former forward at 3. If a lawyer hadn't heard about this, you know, a Black lawyer who played D1 ball and is a member of the class hadn't heard about this, and then couldn't even register his form without having to get advice directly from the law firm that brought the suit to figure out how to file the form. How in the heck is someone who didn't finish school, right, got injured, is working a minimum wage job, how are they supposed to find out about it, right? Especially when the court-approved notification plan only dealt with social media, and there was no specific Black media notification strategy. And so when you say how do we get to Stephen A. Smith, how do we get to the players, you know, it's going to be old-fashioned word of mouth. And you've got my name and number. I can be
This is your law
contacted.
firm, Bradford and Edwards?
Yep,
Is that right?
Yep. It's just there's no ampersand. It's just Bradford Edwards LLP. That's all.
Okay.
Bradford Edwards LLP. The website is www.bradfordedwards.com, and that's it. And so anybody can reach out to me, to my partner Denver. We are both actively involved in simply trying to get the word out. That's all. And it's true. Any D1 athlete of any race from
Check
any
that for me.
sport.
That's right.
Yeah, that's right. Any D1 athlete of any race who played any sport between 2016 and 2024 is eligible, right? But why is there no specific Black media notification strategy when our boys are our young men are the one who built this industry? And that's all we're trying to do, is fill a void. And we know it's already been helpful to some individuals because, as I say, attorney K. Braden Anderson had not heard about this until I contacted him. Undoubtedly, people listening to your show will either be in the class or know people who are in the class, and they'll be able to inform and register and hopefully tell others about it. So,
And so one of the things I've learned today, I feel like I'm in law school, NIL, name, image, likeness.
yep.
This is the legalese of what happens when our brilliant young men and women, when they get utilized for the purposes of sports. This also points to the billions. I mean, this is a whole new level of compensation. And I got to tell you, attorney, what comes to mind is how our athletes, when they are recruited, first round, second round, draft picks, almost like a slave auction block. They're standing up there. I can't help but think of how some of our ancestors, their testicles were, or their penises, or their breasts, they were held up so that people wanting to buy them could see how much man or how much woman. I think of the breeding of our ancestors. I think of how we were treated like animals and how we better get on our A game today. We all on Instagram and TikTok, we're gaming, and we're missing modern day reparations.
Yep. Yep.
And it also gives me hope in this legal system, because I got to tell you this last point. We just got a person in the White House who I know in my heart of hearts wants to get rid of anything that benefits our beautiful people of color.
Yep. I mean, we don't know what position the Trump administration is going to take before Judge Claudia Wilken, whether or not they will maintain the position of the Biden administration. We don't know if this Republican-controlled Congress is going to try to pass an antitrust exemption for the NCAA, which would mean that the NCAA would never have to worry about paying full compensation to players. They could continue the myth of amateurism and only pay room, board, and tuition and that kind of thing. So there are a lot of there are a lot of
unknowns. Is this
unknowns.
talked about on sports shows at the playoff halftime show? Is this being discussed?
No, it's not. The real forum, one of the real forums for a discussion like this is the Congressional Black Caucus. And
Does Kwesi Mfume may know about this? I'm going to text this to him as soon as I get off the air.
Yep. It's important that members of the CBC take the lead here, particularly when Hakeem Jeffries is the minority leader and a lawyer, NYU Law School, my alma mater, NYU Law Review, a very, very brilliant lawyer and legislator. He will certainly understand these issues and how important they are to the community. And why do I say to the community? In our brief in Alston in the Supreme Court, we were making the point that the NCAA rules are robbing Black communities of millions of dollars. If a young man or young woman were able to go to school and get paid $1 million for their
Athletic ability.
Exactly, for their athletic brilliance. Some of that money would likely make its way home to help out there. And so we're talking about, you know, significant resources being held back from the Black community. And when you consider that only 5% of folks go on to the pros, and when you consider that a pro career can be very short as well, right? It can be very short. Monies made and saved for individuals and families while playing D1 ball could significantly improve the living standards for many, many, many Black families. And so this is an economic issue as well, right? People who say that they believe in capitalism and free markets, I believe in them as well. Why don't they work here, right? Why shouldn't a young man or young woman be paid what they're worth, as opposed to there being an artificial ceiling on what they can make, because the colleges got together and said, we only want to pay room, board, and tuition, and we want to keep all the other $1 million in TV revenue that's coming in. It's not right. It's not fair. Unfortunately, it continues to be legal even after Alston, and so we all have to keep pushing so that the young man who plays for 2 years, is injured and then cut from the team, at least has some resources to continue on with his life. So, Mr. Glover, thank you for your time. I appreciate I appreciate the platform. You got my name and number.
I'm going to send some people to you right away.
I'm happy to talk with anyone. Thank you very much.
This angers me, Attorney Bradford. This angers me. It angers me. We just came through the Christmas season. Big time corporations are advertising all kinds of things for us to buy. Our community is the biggest spender in America. We all on TikTok doing these dances. But we got to spread the message about this conversation. And I think our ancestors are very proud of you, sir, and your parents. Because you don't have to do this.
Well, I could say the same for you and your parents. And really, to me, this issue, even though it has an overlay of antitrust and sports management and all of these other things, at the end of the day, you know, it's about fairness. Okay, people should be paid what they're worth, and again, I honestly think that the reason that hasn't happened is because so many of the individuals who are superstars and create the audience, the TV audience that brings in all of this money, are Black, and so.
We may have lost him. Do check out the, oh, there he goes.
Okay.
No, we lost you. You froze up a bit there for a second. Your closing statement, sir.
No, I was just saying, that I think it's incumbent upon Black lawyers, Black members of the media, Black sports superstars to just get the word out. That's all. I mean, it doesn't cost that much. And even if one person benefits, if one Black person who might not otherwise know about this benefits and goes on and registers and maybe down the line gets a little money to help their family, then it will be worth it. So
Good deal. I am proud of you, attorney. And the next time we come to New York City and do one of our Black Wall Street Awards, we'll have to include you. What are you in downtown?
My office is at Midtown. It's at 5th Avenue and 47th Street.
Okay. You ever come up around Malcolm X? You ever come up to Harlem?
I live in Harlem, so I know where Harlem is.
We'll be having a Black Wall Street at the Harlem Business Alliance right there on Malcolm X Boulevard, and we want to recognize you at our very next ceremony. It'll probably be in April.
I know exactly where it is, and I'm happy to join you. I appreciate it.
Yes, sir. We're proud of you. God bless you, Counselor.
You too. Thank you for getting the word out. Appreciate it.
Yes, sir.
Bye-bye.
Good morning, world.